Here at Scott Legal, we process thousands of visa applications. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. One question we receive is whether the O-1 visa is a good option for artists or freelancers who are self-employed. The answer is yes. In this video we explain why. The O-1 visa is a non-immigrant visa classification that can be applied to a broad range of professions. The O-1A is available for those in business, the sciences, and scholarly research. In contrast, O-1B classification is for artists who have received a high level of distinction in their field. Distinction, as used here, means a high level of achievement that is shown by a degree of skill and recognition substantially above that ordinarily encountered. The person should be described as prominent, leading, or well-known in their field of arts. Many talented artists prefer the O-1B visa because it allows flexibility for non-traditional employment structures that many artists work under. For example, an H-1B visa only permits the visa holder to work with one employer. Work done for anyone else requires an additional H-1B visa. The H-1B visa also has a mandatory salary and a labor certification requirement. For the fast-paced arts world, these requirements might be impractical. In contrast, an O-1B visa, through the options described below, allows the artist to accept additional employment that is in the same field she was granted O-1 status, without any need to submit an amended petition to USCIS. For artists who have various freelance revenue streams that are difficult to anticipate, the O-1B classification can provide a good deal of flexibility to accept artistic endeavors as they materialize. In most cases, O-1 visas are filed by an employer, since federal regulations do not allow for O-visa applicants to petition for themselves. However, there are a couple notable options for freelancers or those who are self-employed. First, an agent, which has far fewer obligations than an employer, may file a petition on behalf of the applicant. Second, a legal entity that is owned by the freelancer may file an O-1 petition on their behalf. Let's first discuss the option of applying through an agent. As mentioned before, the O-1 visa allows an agent to petition for the artist to receive the visa. But what does it mean to be an agent? Agents can be thought of as guides who are interested in the development of the artist, but who are acting as a petitioner solely for the purposes of the O-1B filing. The agent does not need to employ or pay any wages to the artist. Instead, the requirements are relatively minimal. The agent must, at a minimum, accept service of process on behalf of the artist, swear that the information in the O-1 petition is accurate, inform USCIS of any materials changes to the artist's proposed employment, and agree to be responsible for the artist's return ticket if and when O-1 status is terminated. Specific examples of agents include professional agencies that represent artists or individuals within a particular industry. However, agents can have a less formal relationship with the applicant, and might even include a friend, an acquaintance, or a business associate. There are specific evidentiary requirements that must be met, depending on the type of relationship between the agent and applicant. However, it is important to keep in mind that the agent does not need to show that it normally serves as an agent outside the context of the O-1 petition. Federal guidance also allows O-1 visa applicants to self-petition through an entity that they wholly own. As with the option of using an agent, this would allow the applicant to perform work in the U.S. for other employers, and to accept additional O-1 caliber engagements in the U.S. that might arise during the validity period of their O-1 status. Of course, whether the applicant uses an agent or self-petitions through an entity they own, the applicant would need to satisfy the fundamental requirements of the O-1 visa. As mentioned before, this includes showing that the applicant has achieved a high level of distinction in their field. If you are considering an O-1 visa or have additional questions about the role of an agent or the process of self-petitioning, Scott Legal is here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.